Good afternoon. I'm calling to order the House Committee on Consumer Protection and Commerce. Today is Wednesday, January 31st, 2024. It is 2 p.m. We are in conference room 329. It's the second committee hearing, so I just want to go over some basic House rules. We're just going to limit testimony to 2 minutes. I'll give you a notification when the 2 minutes is up. Please wrap your testimony when I tell you to. Those who are on Zoom, please keep your microphones off and your videos off until it is your turn to testify. If you are having technical issues, you can contact our IT staff using the chat function. We'll get back to you as soon as your technical issues are resolved. With that, let us move on to the first item on the agenda, HB 2045, relating to automatic renewals. First to testify on this measure, we have Charles Reganent from IHRSA, the Health and Fitness Association, in opposition on Zoom. Not present. Okay. We have written testimony in opposition from Motion Pictures Association. Is any other persons here to testify on this measure? Please go ahead.
Good afternoon, Vice Chair, members of the committee. Mihoko Ito. I'm here on behalf of the Service Contract Industry Council. We submitted comments on this measure, and I apologize if you didn't get it because we did submit it late, so I'll make sure your committee clerk has it. We do have some concerns about this bill and also had some questions about the intent. We would be happy to work with the committee, the introducer, and any other stakeholders on coming up with language that effectuates that intent, but we do have concerns with the language as drafted. And for those reasons, we would ask for a deferral of this bill for now to work on that language and maybe come up with some alternatives for the committee to consider. Thank you very much.
Thank you. Are there any other persons here or on Zoom to testify on this measure? Okay, seeing none, we'll be moving on to Oh, I'm sorry. Yes, Representative Onishi for questions.
Yes, Ms. Ito, if you could. So I know you mentioned some concerns. Can you tell us what those concerns are?
Good question. Thank you for asking. You know, the bill is trying to aim, I think, at service contracts of 1 month or more, and the current law only applies to more than 1 month. But I think there's some inconsistencies in doing that between this section of the law and the greater law itself. So that's why we were confused both about the intent and what this is trying to accomplish. And so I think there is a way it can be worked out. There's also a number of exemptions in the existing law. I think that we'd like to see if, you know, for example, our organization would fit under. So those are the kinds of things we're looking at, but it's mainly a question of how it fits into the greater law.
Okay, so I have a follow-up question. So
Sure.
in reading this bill, do you interpret it as the person who's offering the product or contract having to notify the other person, the person who's receiving it, every time there's a renewal?
Yes, I think so. I think notice is the key part of this section of the law, is notice upon renewal.
Okay. Okay, thank you.
Sure.
Thank you. Members, are there any other questions? Okay. Seeing none, we'll be moving on to HB 2148 relating to professional land surveyors. First to testify, we have Sheena Choi from the Board of Professional Engineering, Architects, Surveyors, and Landscape Architects with comments. Thank you. For the record, when you do testify, please come to the podium. I know some of them are pretty short, but just for the record, so people on Zoom can hear you as well. Yeah, just very quickly, thank you.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Sheena Choi, and I'm the Executive Officer for the Board of Professional Engineers, Surveyors, and Landscape Architects. The board would like to stand on its written testimony, and I'm available for any questions. Thank you.
Thank you. Next, we have Meyer Cummins, Hawaii Land Surveyors Association, in support.
Hello, Vice Chair, members of the committee. Mahalo for this opportunity to testify in support of HB 2148. My name is Meyer Cummins, and I'm a land surveyor. I'm also the son of two local land surveyors who own their own business and ran it successfully for over 30 years. As the son of small business owners, I grew up in a house full of boxes and file cabinets filled with maps, field books, contracts, and every year the house would fill it with more and more of these records. They were in the kitchen, in the living room, in the closets. They were in the garage and in the washroom. They were everywhere in the house. Finally, when they started piling up in my bedroom, I asked my dad, why do we need all this stuff? And my dad would say, because you never know when you might get dragged into court to prove that you didn't make a mistake. Thankfully, my parents didn't make mistakes. They never had to go to court because someone thought they found an error in their surveys. But that didn't prevent them from having to keep all their records to prove it, even decades after the work was completed. My dad died last April after serving in Hawaii for over 50 years. And you know what? His house is still filled with those boxes and those records. So for that for that reason, I can say that this bill is about relief. HB 2148 provides relief for land surveyors who have been surveying in Hawaii for decades with worry on their minds. Not because they did anything wrong, but because there is always a chance that someone will blame them for a mistake that they didn't make and have to hope that despite the records they keep, nothing and no one disturbed the evidence of their survey from years before. HB 2148 provides relief for surveying firms that have been surveying in Hawaii for decades with different surveyors at different times, surveyors that have moved on or passed away, surveyors who can no longer testify to the quality of their work, but because they are gone, they put the company at risk if litigation arises and the evidence and records of survey are missing or no longer legible. I support HB 2148 because it can provide some relief to surveyors after a reasonable time, a period that I leave to the wisdom of the committee to determine, where no injury arises from a completed survey. I think that's fair and just. And if this bill passes, I can go home and help my mom clean out some of the boxes and file cabinets that are still in her house. Mahalo, I am available for questions.
Thank you. Next, we have we have Joanne Williamson from the Hawaii Land Surveyors Associations in support.
Hi, my name is Joanne Williamson. Thank you for having me speak, Mr. Vice Chair and members of the committee. I stand on my written testimony. I believe this is in favor of surveying small business around the state, and for the members of the community, that this is an legislation which will adequately take care of any damages and lawsuits by limiting the time frame of liability. Thank you.
Thank you. Next, we have Alika Garov, an individual in support. Are they on Zoom? Okay. We have written testimony in support from another individual from the Hawaii Land Surveyors Association, as well as about a dozen written testimony in support from individuals on this measure. Are there any other persons here to testify on this measure or on Zoom? Okay, seeing none, members, are there any questions? Yes, Representative Oishi, please.
Yeah, first, I guess, Ms. Williamson, if you could please come up. Thank you for being here. So you're with the professional land surveyors, right?
Yeah, it's the local professional society is Hawaii Land Surveyors Association.
Do you
Yes,
have
sir.
any data or information on how many lawsuits have come up regarding the work that surveyors have done?
I do not. I know that sometimes that they are swept up in a larger lawsuit as, you know, a possible litigation. May I defer to Meyer, who might know?
If he does, yeah, that's fine.
Sorry, Meyer.
Although their family hasn't had any.
No, not in my family, no. I have served as the president of HLSA. Most of what I have is anecdotal evidence. However, we can get that data and provide it to the committee if that's what you want. We have no problem with that.
Okay.
But most of what I know A lot of survey errors are caught within the first 10 years, and usually they're dragged in with other design professionals. And a lot of times it settles just going through E&O insurance, but that's still costly. Every time there is a settlement and you have to go through insurance, your insurance goes up. And it becomes really difficult if after 20 years, 30 years go by, if you don't have sufficient records or there's not a lot of witnesses to the survey that you did, oftentimes you are you're usually incapable of sufficiently showing you didn't make a mistake, so you end up settling anyway. The reason why this bill is important is because after a certain period, if no injury arises, it just seems reasonable that the surveyor shouldn't have to continually worry. One of the main concerns that I am aware of is other legacy firms that have been surveying for 50, 60 years in the state. You've got people who buy those businesses or people who rise up through the ranks, and the original surveyors, the principal surveyors that did the survey, have passed away, and now the new surveyor who's in charge of the firm is worried about the liability from surveys in past, and they can't speak to how that survey was conducted necessarily. And the records may not have been preserved over 6 decades, for example. So I can name a few companies who are concerned about this situation. Walter P. Thompson is one company. There's another one, West Thomas and Associates, with these long-time firms that had multiple surveyors surveying for the firms. After so many years, again, it's difficult to make sure even if your records are in place, again, you might not have witnesses, or your survey might have been disturbed years before, either by natural causes or other players, and you won't be able to prove it because so much time has passed. So that's why the bill is important.
Okay, well, that's what I was interested in, is how far back have these suits been brought up on surveys from the past? So,
We can get you that information. We can tap the people that we know at the different companies and get their information.
Thank you. You can submit that information to the chair and myself, and we'll disseminate it.
Thank you very much. Appreciate that.
Thank you. Representative Purick.
This question is for you again, Myers. Thank you. Is it too cumbersome to just digitalize all of these entries?
So in the case of my family, it was a small business. So many files over time evolved to be digitized. But you're talking a house full of maps and documents and contracts. My parents simply didn't have the money or the time to do it. And they had offices for a while, but the cost to keep these expanding records in the office was just too much on my parents. So they started to just move everything home, and eventually they just moved their whole business home. So there are ways to digitize everything, but those costs will eventually have to be passed down to the client. And then you still have to pay for servers, keep those servers running, So there are costs involved. Even if space no longer becomes an issue, the cost to maintain even digital records will start showing up in the cost for surveys. Mm-hmm. Yeah.
Thank you. And would you recommend like 15 years as a no complaint window?
Well, there is an existing statute of repose for injuries related to real property improvements that's set at 10 years. I think that's reasonable. However, even 20 years would be good, considering that at 20 years is the statutory period for adverse possession. So if the state's going to allow for people to adversely possess property after 20 years, I think it's probably fair that within a 20-year window, people should have looked into possible errors with their boundaries or discrepancies. So somewhere between 10 and 15 years, I think, is fair.
Thank you.
Yeah, no problem. Okay.
Thank you. Members, are there any other questions? Okay, seeing none, we'll be moving on to HB 2085 relating to the Residential Landlord-Tenant Code. First to testify on this measure, we have Mana Moriarty from DCCA in opposition.
Thank you. Good afternoon. You've seen our comments in opposition. I want to note we're supportive of the intent. This bill is not an outlier. Look, we've got model law in Washington and California, and in Washington, they've written into their law reusable tenant screening reports. Now, it's optional. It's not mandatory. But what did that do? What that did was it gave the green light to the private sector to innovate. And so at this moment in time, we have tenant screening companies out there who are providing tools for tenants who are giving them the keys to pay one time and use that report and have it available to all landlords whom they're applying to. Now, let me address maybe the concern that landlords will be passing information between each other, and they shouldn't have to do that. Well, landlords already have an obligation under existing state and federal laws to keep information that's sensitive and personal private. This bill would impose no new obligations on landlords, property managers, landlords' agents. And let me again say that the private sector has innovated in response to Washington and California's pushes in this area. And the private sector has provided the keys. There are companies out there, including Single Key, I believe it's called myscreeningreport.com, that are willing to accept the risk and are willing to bear the risk of securely transmitting information to landlords. And lastly, let me say that we also believe there's some urgency, particularly for landlords on Maui and tenants on Maui who may be looking at a situation where they're applying to 10 units at a cost of $30 per application. The legislature absolutely should be considering solutions to aid these tenants. And it strikes me as we don't often talk about moral imperatives at the legislature, but for landlords on Maui who may be looking at far above market subsidies for rental housing, receiving them, they should be asking themselves, and indeed industry should be taking an introspective look at whether the landlord can bear the cost better than a tenant or a prospective tenant who has lost their property. Available to answer questions.
Thank you. Next, we have Lindsay Garcia from the Hawaii Realtors in opposition.
Thank you, Vice Chair, members of the committee. My name is Lindsay Garcia from the Hawaii Association of Realtors, and we stand on our testimony as submitted. Thank you.
Thank you. Next, we have Sergio Alcubilla from the Hawaii Workers Center in support.
Good morning, Vice Chair and members of this committee. My name is Sergio Alcubilla. I'm the Executive Director of the Hawaii Workers Center. We're a nonprofit organization that focuses on empowering low-wage workers to organize for their own political, social, and economic well-being. We're in support of this bill for two reasons. First is just the negative impact that rental application fees have on members of our COFA Workers Association. And second, just what we're seeing on Maui in terms of some of the practices that landlords are currently doing to collect some of these fees. Last year, we helped members of our COFA Workers Association fight back against their landlord to ask for repairs to make sure that their place was livable, habitable. Instead of making those repairs, the landlord ended up kicking everyone out. So, members of our association had to go find housing. It's been difficult finding affordable housing for them. A lot of them, they don't have the rental history, those references, that some of us take for granted. And for a family where many of the workers are low-wage, minimum wage workers, paying $200, $150 for an application fee, it's just very hard. It puts a strain on families' resources. Second, we have an organizer on Maui. She's actually submitted written testimony as well, but her family was one of those that were impacted by the disaster. Out of desperation, they tried to find housing after their house burned down, and they submitted rental applications to a lot of places, right? And for some of them, they'd never heard back from the landlord, but at the same time, they continue to see the unit still being advertised. Right, so that was something that was really brought up, and we've spoken with other folks in Maui as well that that's something that they're experiencing, that they submit the rental application fee and just never hear back. And just to end, this is really an issue of equity. For our COFA member association, for members of our COFA Workers Association, really for our working families, and just for our renters. If you can recall just applying for college, and sometimes if you're on low income, or if you didn't have the income, but those college application fees would make you think twice about submitting your application, right? So how much more for something as important as housing? Again, thank you, Vice Chair, for letting me testify on this in support.
Thank you. Next, we have Nikhil Kurana, individual in support on Zoom. Present, okay. We have written testimony in support from about a dozen individuals. Are there any other persons here to testify on this measure in the room or on Zoom? No, please step up to the podium.
Hello, Chair and Vice Chair. Good afternoon, everyone. My name is Alberina Crielmo, and I am a member of COA Citizen Association at the Hawaii Workers Center. We came to Hawaii from Bombay so our daughter could receive medical treatment here. We moved into a place near hospital so we could be close to her. The place that was rented out by a relative who was moving. We paid $15.50 a month, and the place did not have electricity, working plumbing, and rats were everywhere. At the time, we did not know our rights because we were new to Hawaii and we kept paying rent to the landlord. The problem became really bad and we kept asking our landlord if she could fix them. It was at the Hawaii Workers Center that we began to know our rights. When we demanded that the landlord make the repairs and to also turn the water back on, she evicted everyone that complained. We had no choice but to find another place. It's been hard applying for a place because our only renting history is only with that landlord, and she tells other landlords not to rent to us. Every time we apply for a place, it costs us almost $200. I live with my husband, our 2 sons, and our daughter-in-laws, and it's been really hard to keep applying, paying the application fees, and the landlords tell us no. We hope to find a place soon, and we are thankful to the many groups like the Hawaii Workers Centers that is trying to help us. Thank you for your time and letting me share our story.
Thank you. Are there any other persons here to testify on this measure? Okay, seeing none, members, any questions?
Yeah, Vice Chair.
Please go ahead, Representative Onishi.
Yeah. For DCCA, I know you mentioned that there are laws that protect the confidentiality of information from one landlord having to give it to another, correct?
The laws that exist protect that information regardless of to whom it's being transferred. So if the landlord receives it now, they're obligated to keep it confidential and dispose of it in accordance with law.
Okay, what about disclosing it to the applicant?
It's not a question that I know the answer to offhand.
Okay, because that's what this bill asks for, right?
That is not how I read this bill. It does not require, I think, disclosure necessarily to the applicant. Let me take a moment to just check, Representative. I don't want to misspeak. So I don't see in this bill that there's any requirement for a landlord to provide an applicant a copy of the credit report or background check. If I'm missing something,
Okay,
please let me know.
maybe it's not really specific to that wording, but it does say in this bill, if an applicant provides a landlord or the landlord's agent with a certified copy of the applicant's criminal background check or credit report received within 30 days from another landlord or that landlord's agent.
Understood. I see where you're coming from. And yeah, apologies.
So it
That's
sort of
probably my
assumes
oversight.
that,
They are getting it from the landlord.
yeah, from
Understood.
whoever they applied to.
Right.
But does the law prohibit that?
Not that I'm aware of, no.
Okay. So you brought up an interesting situation in other states where they allow for the applicant to do a one-time request for this background check and credit check, and it's certified by this organization. Is that the direction that maybe Hawaii should be headed towards versus this, where we're trying to make the landlord more responsible than the person doing the application?
I think that's exactly sort of the tough policy question, right? You've hit it. Should the private sector be providing the remedy, providing innovation? We're interested in looking at how effective that has been. Certainly, if you write it into law, we know that the private sector will respond, right? There's that potential for innovation and for the private sector to provide a solution apart from any government mandate
Yeah,
and its
so-
associated costs.
And I realize 30 days is a very short window, but maybe expanding that credit check or background check to like 60 days would be more beneficial to the person doing the application, so that it's not, where they're gonna have to do it every 30 days, right? So, okay, well, thank you. Thanks for that.
Members, are there any further questions? If not, I do have several questions, Mr. Moriarty. So in your testimony, you did note that there are private tenant screening companies that allow tenants to share this report at no additional cost. I'm just curious, we've heard $100, $200 from you, $30 per application fee. Do you know what the standard or average fee is for this kind of screening?
It's a great question. I don't know if there's a standard, and I'm not aware that the law creates a standard. So one way to view it is that you can get all the information you need with a $25 background check. If you want to be, let's say, extra diligent, you can pay the premium and pay the $150. Now, what is the standard that we want to require by law? This was an issue that came before the legislature last session, and I'm not aware of an average. I can give you caps that are applicable in other states. I can find that information and share it.
Yeah, I'd appreciate that. Would that be preferable to what this bill currently is, instead of creating a certification process and regulation of this certified copy, just creating a cap on a fee? It won't eliminate the fee, but it will make it more affordable, I suppose.
So let me just preface the answer with OCP provides information to both landlords and tenants, is not an advocate for either. Mm-hmm. But let me outline the policy consideration, right? If you have a cap of $25 per applicant, and the applicant is applying still to 8 or 10 places, you're looking at $150 or $200. Now, if you're looking at Single Key or My Screening Report, one of these private solutions, you might be looking at a one-time payment of $39.99 that all 8 of those landlords could then access. And let me mention, in case it got lost, that these private sector solutions are bearing the risk of insecure transmission of information, right? They are agreeing that they will transmit the information securely and are responsible for compliance with federal and state law confidentiality requirements.
Okay. And so I assume that's what you're mentioning when you have in your written testimony, requiring landlords and their agents to accept these reports would reduce the cost to the applicants. You mean HRS would require landlords to accept these credit or criminal background checks?
So I'm not aware of anything to stop the legislature from mandating that a landlord accept a reusable screening report. And I think it's entirely appropriate. Well, let me say this. I'm curious what the response has been in the private sector here in Hawaii. We know there's an unfolding tragedy on Maui, and I'm curious whether the property managers and landlords have told their clients that it's appropriate under these circumstances to waive application fees. And if not, why not? Until the time where the industry is telling their clients that, look, the cost should be borne by you, then I think it's entirely appropriate for the legislature to hold their feet to the fire if they're not using the tools at their disposal to respond to this once-in-a-lifetime event.
Okay. No further questions for DCCA. Hoy Realtors. So I'm sure you were just listening to
Yes.
Mr. Moriarty's testimony and answers. What do you feel about mandating landlords to accept these reusable screening reports?
So as I stated in my testimony, and as Mon has also pointed out, there is my understanding is that these screening reports, these background checks are supposed to be confidential. And so there is a risk there with requiring their transmittal. We understand where the intention of the bill is coming from, and we'd be happy to kind of take this feedback back and try to get more commentary from my members in order to see how we can work together on this measure.
Okay, thank you.
Thank you.
Members, any further questions? Seeing none, we'll be moving on to the next item on the agenda. This is HB 2192 relating to cemeteries. First to testify, we have Chelsea Fukunaga from DCCA in support.
Good afternoon, Chair, Vice Chair, members of the committee. Chelsea Fukunaga on behalf of the Cemetery and Funeral Trust Program with the DCCA, testifying in support of this measure. This bill will permit the director of the DCCA to appoint a limited owner of a cemetery for which no owner can be found, and will authorize the limited owner to file complaints with appropriate law enforcement authorities against illegal acts conducted in the cemetery and install security measures to deter trespassers from entering the property. Although the proposed amendments to Chapter 662D will not solve all the concerns regarding Sunset Memorial, the department hopes that this measure will create a foundation to secure the property and support community efforts to keep the cemetery crime and litter free. Thank you.
Thank you. Next, we have Larry Verre from the Pearl City Neighborhood Board number 21 in support.
Good afternoon and aloha, Vice Chair Sayama and committee members. I'm Larry Verre, and I want to thank you for allowing me the opportunity to provide testimony in strong support of HB 2192, a very important House bill that could positively impact hundreds of families who have their loved ones buried and interred at Sunset Memorial Park Cemetery. As the chair of the Pearl City Neighborhood Board, I'm submitting this testimony representing our board as a whole. We've submitted many resolutions to move to improve that cemetery, and the numerous residents who live in Pearl City and on the island of Oahu. For the past decade, Sunset Memorial Park Cemetery has been pillaged by homeless transients, desecrating hundreds of family plots, mausoleums, and crypts. Since the owner died over a decade ago, community volunteers, veterans, church groups, and nonprofits groups have groomed the cemetery, trying to keep it presentable despite the many challenges in maintaining the cemetery. I've taken the lead forming the Friends for Sunset Memorial Park Cemetery domestic nonprofit, which is made up of proven community leaders who care about those families of the cemetery. The nonprofit mission is to secure, improve the cemetery's appearance, and find a creative, innovative, and resourceful idea to obtain special funding grants to generate the much-needed funds to support contract maintenance and make the necessary costly repairs to the cemetery without putting a burden on the public for continued volunteer work. HB 1292 amends Chapter 662D, Hawaii's revised statutes, which allows the DCCA to appoint that limited owner to trespass desecrators of the cemetery and install security measures to prevent illegal trespassers from pillaging the cemetery. I ask you, please, add two more provisions. Whoever is appointed as limited owner to provide annual reports to the DCCA showing the progress improving the cemetery. And secondly, importantly, DCCA give authority to the limited owner to contract major repairs for the cemetery, such as tree trimming, electrical, water connections, and potentially integration of a solar voltaic capability to generate long-term funding to support the cemetery. In closing, I most strongly urge you to approve this bill. This could open the door for potentially nonprofit to be selected by the DCCA for the protection, repair, betterment, and beautification of the cemetery. And importantly, these aforementioned initiatives could serve as the model solution for the state and the DCCA, supporting other abandoned cemeteries in Hawaii. Mahalo. And I'm taking a lead on this. This has taken 12 years of my life on the Pearl City Neighborhood Board. We're going to turn that cemetery around. Thank you.
Thank you. We have written testimony in support from 3 individuals. Are there any other persons? Oh, please go ahead.
Good afternoon, members and Vice Chair and Chair. Before I start, I want to disclose.
Sorry, for the record,
I'm sorry, my name is Maureen Andrade.
Thank you.
They call me Mo here. I want to disclose that I am on a 1-hour vacation to testify. First of all, I support Larry very much. We've been working with Larry for a very long time on this graveyard, this cemetery. My 5 ancestors, I have 5 people in my family, how you say, I have 2 great-grandparents, my mom, my dad, my sister, and my uncle buried there. And I am there every Sunday unless it's raining or I'm sick. And I've been doing this for many years. When I was at the house side, I testified explaining that we have cleaned that area with Larry and with a lot of the military people and people from Waipahu and Pearl City and outside of the area. The cemetery does not only hold people in Pearl City. They have people coming from on the other side of the island. My grandparents came from Nanakuli. We have worked really hard to kind of clean up this place. And I want to thank DCCA for putting up with us and actually going this far with us. We need more support. And to have that place come back to even half of what it was at the beginning. My sister died in 57. My mom died in 1959. I was 6 then. And there's people, from the plantation area time that have been buried there longer than my family. But in recent years, and I want to say in the last 20 years, that place has been desecrated. It's been, we cleared out homeless so many times. They've done so much drugs and everything else there. So now that it's slowly getting, it's not perfect. It's not going to be perfect for many, many years, but we got rid of a lot of the homeless. There's a lot of graves that have sunk to the point where if I was to stand in it, you wouldn't see the top of my head. There's a lot of older Japanese and Chinese people that come there on the weekends that don't realize that there's no water. So my family and I usually go there, either myself and my son-in-law and my daughter. We bring extra water,
Sorry,
and
I just
so.
want to remind you,
go ahead.
2 minutes is up, so please wrap
But
your
I want to say that I really highly ask that you folks support this bill. Thank you so much for your time.
Thank you. Are there any other persons in the room or on Zoom here to testify on this measure? Okay, seeing none, members, are there any questions?
Yeah, sorry. I got
No.
a question.
Representative Onishi.
DCCA, if you could please come up. Thank you for being here. I guess this is a situation where it says the owner passed away and there's no heirs.
So it was owned by a corporation that is now defunct, and the last officer has passed away. So it's a unique situation currently.
Okay, so what's the disposition then of this? Is it now the state's responsibility?
It's considered abandoned right now.
Okay, and what happens to abandoned property?
I'm not fully aware of that statute.
Okay, so the law would then allow DCCA to appoint somebody to take care of this abandoned property?
So this is amending the volunteer statute, and it would, if the proposed amendments go through, it would allow the DCCA to appoint an interim owner. Yes.
Okay, so DCCA would vet different organizations
Yes.
that would be interested,
They would have the authority to do so, yes.
specifically for abandoned property.
Not abandoned property, it's specific to
Just
cemetery,
cemeteries.
yes.
Okay, I notice in here you're giving them different kinds of rights in order to security, perpetual care, etc., operations. Who's going to end up paying for all of this?
So it is, it would be incumbent on whoever the interim owner would be to come up with those funds. So if it's a volunteer organization, if they're gonna fundraise that. And the, what it's authorizing, if the limited ownership is granted, it's just for the purposes of securing the property. If it's a fence, and it's gonna allow for the limited owner to trespass individuals. So as the complaints are coming in and there's people that they're unable to remove from the cemetery and they're causing safety concerns, it would allow this owner to contact the authorities to then eventually remove these individuals. So it's very limited in scope of what this is gonna allow the limited owner to do.
So it doesn't necessarily address all the issues with the cemetery.
Again, yes, it doesn't address everything. We're just creating like we're trying to address the major concerns. And we do admit that it's not a end-all be-all solution. So this is just the beginning.
Okay. Okay, thank you. Thank you, Chair.
Thank you. Actually, I do have some questions for DCCA as well. This bill amends Chapter 662D, which relates to immunity and volunteer service, as you mentioned. But also, this relates to cemeteries, right? So does it fit better in HRS 441 that relates to cemeteries and funeral trusts? Was there like a specific rationale there?
For the volunteer, we're looking at trying to indemnify any volunteers from any type of like lawsuit if they're acting in good faith. So if they're volunteering and something should happen, we're using this to, there's provisions within this statute that would allow for that, so.
But if we amend Chapter 662D, does that fall under DCCA's purview still? As
I'm not aware of who actually oversees 662D, but there already is, it was through Act 198, and we have a volunteer statute which basically allowed volunteers to come on the property and clean up without fear of being sued for anything. And so we're falling within line with that. There's already an established section, so we're just expanding upon it.
okay, and I just want to understand the kind of the scope or how specific this issue is. Do you find this particular situation happening in other areas of the state or other cemeteries?
I don't have, I can't speak to that right now. I don't have any information on that. We do hear reports, but I don't have anything official or official complaints regarding that.
Okay. And what do you think of Mr. Verre's request for amendment that the entity responsible for the cemetery submit annual reports to DCCA?
I have to get back to you on that. I'm not sure.
Okay. I see Mr. Verre kind of nodding his head in the back, so I'll bring you up to the podium. Let's answer a second question about, how frequent is this issue seen in the state of Hawaii?
This is happening all over all the Hawaiian Islands. These cemeteries where the owners have passed away, the state does not want to take ownership of them. It sets a precedence for them. So that's been the big issue. I've been trying to get the state to do this for many years, and I can understand their situation. But right now, our volunteers, thank goodness, the DCCA came through and and they're covering for us for liability. But we're very limited. Cleaning up the cemetery is one thing, but when you have mausoleums collapsing, that's a safety issue. Those have to be repaired. And of course, you didn't hear the horror stories about the homeless. We still got them living in those mausoleums, and I can't trespass them.
Okay. Can you answer this? I think it was going back to Representative Onishin's line of questioning about jurisdiction. So is this cemetery, okay, the board member for the corporation passed, there's no one to take over. Is it city and county of Honolulu property, or is it, what is it?
I believe it's still state property because the state is, it's abandoned cemeteries, so the state always is the one that takes those things. Okay. And all we are is a caretaker. That limited ownership, we really, there's no deed or anything like that. We're just there underneath the DCCA as a sponsor and allowing us to do what we need to do to upkeep the cemetery.
Okay, thank you. No further questions.
All right, well, thank you all.
Members, are there any further questions? Okay, seeing none, we'll be moving on to the next item. HB 2048 relating to Hawaii Property Insurance Association. First to testify on this measure, we have Gordon Ito from DCCA with comments.
Good afternoon, Vice Chair Sayama, members of the committee. Gordon Ito testifying on behalf of DCCA Insurance Division. Just a little correction to our testimony. The department supports the intent of the bill. With respect to HPIA, I believe the intent of the bill is to encourage or have more representative public participation. When I looked at the bill, not the bill, but the HPI board composition right now, there's 8 members appointed by the insurance industry. 3 members are appointed by the insurance commissioner to be representative of the public. And then there's 1 member that's an insurance agent. I think in terms of trying to meet the intent of this bill, perhaps in looking at the appointments that were made with the public member, at least from my perspective as the insurance commissioner, when I was commissioner between 2010 and 2018, I really wanted to have a truly public member appointed, and like right now, the 1 public member I feel is really represented the public. He's a contractor from the Big Island. He's been on the board. He's been an excellent board member. That is what I view as a true public member. And this is not a knock on the other 2 public members, but currently when I looked at the board composition, 2 of the other public members are insurance agents. And so in terms of trying to be representative of the public, maybe the law should be amended to require the public member to be not involved in the insurance industry and to be represented. And I think that might be a proposed amendment to really have truly public member represent the public on the HPIA board. As to who appoints, I believe way back when the HPO was created in the late 80s because of the call upon I think for expediency purposes, I believe that's in part why they had the commissioner appoint the public members. I defer to the legislature as to whether they want to change the appointment to have the speaker as well as a Senate president be the ones appointing the public member. But that's really my recommendation in terms of ensuring that we have really represented public members. Like I remember a few years ago when I appointed the other public member from Kauai, that person used to be an employee of the board of water supply on Kauai. So I felt that person, was not involved in the insurance industry, and it's really reflective of public, the public to represent on the board. So that would be my recommendation. I'll be glad to answer any questions.
Thank you. We have written testimony with comments from Puna Citizen for Affordable and Sustainable Property Insurance, Hawaii Property Insurance Association with comments, and 8 individuals in support. Are there any other persons here in the room or on Zoom to testify on this measure? Seeing none, members, are there any questions? Okay, we'll be moving on to the next item on the agenda. HB 2056 relating to insurance. First to testify on this measure, we have Gordon Ito from DCCA with comments.
Again, stand on our written testimony. We support the intent of the bill. I'd just like to note that, and more specific information with respect to, on January 15th, Representative Adam Schiff from California had forwarded a proposal for the federal government to create a $50 billion backstop, for catastrophe losses. So there are discussions in Congress as well as among fellow commissioners. We've talked about how do we, try to address some of these catastrophic losses that have been occurring, and is really creating this very extremely hard insurance market that not only Hawaii has experienced, but nationwide. I'll be glad to answer any questions.
Thank you. Next, we have Lindsay Garcia from Hawaii Realtors in support.
Good afternoon again, Vice Chair and members. My name is Lindsay Garcia from Hawaii Realtors, and we stand on our testimony offering support.
Thank you. We have written testimony in opposition from the Reinsurance Association of America, as well as an individual, and written testimony in support from 10 individuals. Are there any other persons here to testify on this measure? Seeing none, members, are there any questions? Okay. Seeing none, we'll be moving on to the final measure, HB 2165, relating to rent control. First to testify on this measure, we have Christopher Han or Byron Yee from the Attorney General's office with comments.
Good afternoon, Deputy Attorney General Christopher Hahn with comments. We recommend amending the bill to incorporate some exceptions, include a preamble, and insert the bill into Chapter 521. Thank you.
Thank you. Next, we have Lahaina Strong in support on Zoom.
There are no testifiers present on Zoom.
Thank you. Okay, we'll be moving on to Lindsay Garcia, Hawaii Realtors with comments.
Thank you, Vice Chair and members of the committee. Lindsay Garcia from Hawaii Realtors, and we stand on our comments. Thank you.
Thank you. Okay, we have written testimony in support from the Democratic Party of Hawaii, Hawaii Financial Services, LLC, Honolulu Tenants Union, Unite Here Local 5, and many individuals. Actually, many individuals. And then we have written testimony with comments from the Grassroots Institute of Hawaii. Members, are there any questions? Okay, actually, I have a question for the Attorney Generals. So I was under the impression that the governor's current emergency proclamation kind of had rent control incorporated within that. So is that still in effect?
Yes, the moratorium is still in effect.
Okay. And as long as the governor renews that emergency proclamation, the moratorium will be in effect. Does that sound about right?
That sounds about right.
So in effect, this bill is only putting that moratorium into legislation, and then it will be sunsetting 2025.
That is our understanding.
Okay. Okay, no, that's about it. Thank you.
Thank you.
Oh.
Chair, may I?
Yes, Representative
Question
Amato.
for the Attorney General. Thank you, Chair. Does this measure include commercial property?
That was not my reading of the bill. Let me just take another look at it, if that's all right with you.
I can answer it. It doesn't.
Yeah, it doesn't seem to be the case. Yeah.
It does not. So I ask because I represent South Maui, and as a result of the fire, many of our small businesses are being displaced because landlords are like, oh, hey, I'm not renewing your lease, or, oh, I want to make some changes, because they're finding they can charge triple, 30 to 40% higher.
So is there a
So
question?
is there a recommendation by chance that this does include commercial property? Would that benefit the community?
We don't have a position on that matter,
Okay.
but I would like to note that we've noticed a number of bills on this subject matter, and some of them seem to include rent control provisions for commercial areas.
Thank you.
Thank you.
Okay, members, any further questions? Okay, seeing none, we'll be taking a short recess for decision making. Recess. Okay, reconvening the House Committee on Consumer Protection and Commerce. We're going to start with the decision making on HB 2045 relating to automatic renewals. We'll be amending this bill to add language that says a business who sells or offers to sell any product or service to a consumer via a subscription of 1 month or more that includes an automatic renewal clause shall notify subscribers 1 month prior to any change of prescription, giving the consumers the options to retain or cancel their prescription. This amendment will basically make sure that any contract renewal of less than a month, make sure that the consumer understands that if there are any changes to the contract, whether that's a price change or any change in the contract, that the consumer consumer have the option to renew that contract. Okay, so with that, Representative Onishi for, any questions? Okay, seeing none, Representative Onishi for the vote.
Okay, on HB 2045, recommendation is to pass with amendments. Chair Nakashima is excused. Vice Chair Sayama.
Aye.
Representative Amato.
Aye.
Representative Baladi.
Aye.
Representative Hashem.
Aye.
Representative Hussey Burdick. Representative Gates.
Aye.
Representative Lowen excused. Representative Onishi votes aye. Representative Tams excused. Representative Perrick. Chair, your recommendation is adopted.
Thank you. Moving on to HB 2148 relating to professional land surveyors. Okay, we'll be putting in 20 years for the statute of repose. We'll be defecting the year to 3000 and making technical amendments needed for clarity, consistency, and style. Members, any questions? Okay, seeing none, Representative Onishi for the vote.
Okay, HB 2148. Recommendation is passed with amendments, noting the absence of Representatives Nakashima, Lowen, and Tam. Anyone voting with reservations? Anyone voting no? Chair, your recommendation is adopted.
Thank you. Moving on to HB 2085 relating to the Residential Landlord-Tenant Code. Members, we'll be deferring this decision-making for next week. We believe that there's a lot of merit to this bill. However, there needs to be some work done, and we're going to contact DCCA to work with them. Okay, moving on to HB 2192 relating to cemeteries. We'll be making technical amendments needed for clarity, consistency, and style. I believe we could defect the date on this one to year 3000. Members, any questions? Okay, seeing none, Representative Nishi for the vote.
Okay, HB 2192, recommendation is passed with amendments, noting the absence of Representatives Nakashima, Lowen, and Tam. Anyone voting with reservations? Anyone voting no? Chair, your recommendation is adopted.
Thank you. Moving on to HB 2048 relating to the Hawaii Property Insurance Association. For this one, we'll just be defecting the date to year 3000. Members, any questions? Okay, seeing none, Representative Onishi for the vote.
Okay, HB 2048, recommendation is passed with amendments, noting the absence of Representatives Nakashima, Lowen, and Tam. Anyone voting with reservations? Anyone voting no? Chair, your recommendation is adopted.
Thank you. Moving on to HB 2056 relating to insurance. This measure will be amending, deleting lines 20 on page 2, and we'll be defecting the date to July 1st, 2000. We will also change languages on page 3 to invite members of the private industry instead of require them to participate in this working group. We'll also amend page 3, lines 16 to 18. This would be deleting references to Chapter 84 of HRS, and we'll maintain a blank appropriation amount. Okay, members, any questions? Okay, seeing none, Representative Onishi for the vote.
Okay, HB 2056, recommendation is passed with amendments, noting the absence of Representatives Nakashima, Lowen, and Tam. Anyone voting with reservations? Anyone voting no? Chair, your recommendation's adopted.
Thank you. Finally, HB 2165 relating to rent control. Members, I'd like to be deferring this measure. I believe that the governor's emergency proclamation already covers the intent of this measure. With that, this hearing is adjourned. Thank you.